Yeah. Welcome all the participants. Uh, I hereby welcome all the participants with the request that they should keep their mic off and video on so that it should boost the morale of the speaker. Today's speaker is Ms. Anita Bafna, advocate on record. Today, now she is going to share her views and experience and informing you the procedure of drafting in Supreme Court, which will be helpful to all of you in your second paper of drafting or advocate on record examinations. Welcome, Anita ji. Now it's over to you.
Good evening. Good evening, all the participants. Today we are going to discuss the paper 2, that is drafting, which is one of the very important paper of, I will say, not only for the purpose of the drafting paper of AOR examination, but also for our lifetime, our profession as a lawyer. So because drafting helps you throughout your life, and if your drafting is good, 50% battle is won. I have heard in the corridors of the Supreme Court that 50% of the drafting which decides your life of the case, then 25% client's luck and 25% on the counsel's arguments. So now you understand what is the drafting. We will discuss some of the parts of the SLP. See, Supreme Court breathes in and out of the 136. Everything, I think 90% of the cases in the Supreme Court are of 136 of the Constitution. So Article 136 should be thorough when you appear for the drafting paper. First thing I would like all of you to tell you that whenever you do drafting, always remember that you should be able to write faster. Most of the people who has appeared for drafting paper, they know in the past that you are unable to complete the paper. The reason behind that, because it is one of the lengthiest papers, so it is very difficult. So always remember, whenever you are appearing for drafting paper, try to divide your time for each things, for each question, each answers, whatever you write. If you keep on writing one SLP for 1 hour, then you will miss the balance paper. So always remember, try to divide the time for the questions. Now, first thing I would always ask all of you that please read the instruction at the top of the question paper. I have taken out the question paper of 2018 just for example. So in 2018 this paper, there are instructions that 30 minutes will be given extra to you to read the question paper. Then also your writing should be legible. Then there are options given. See, sometimes we do not read the instruction at the top. The options are that question 1 or 2, out either of that you opt for one. So it will be easier for you. Also, there are sometimes notes that do not write the certificate and affidavit not required. So you don't waste time on that. So you don't waste time on that. So always remember, there is one thing. Now we will discuss the part of the SLP. The first part of the SLP is synopsis. See, synopsis, what is synopsis? Synopsis is always a gist of the case. I have heard from the many learned lawyers that judges mostly read the synopsis and list of dates. So there are two parts of the synopsis. One is synopsis, the gist of the case from which high court it is coming, and also what is the issue and what are you seeking, what is the error. And then number 2 is list of dates. Though he knows or the examiner knows what are you or even the judge, if you are drafting the SLP, what is the requirement and what is the relief you are seeking from them. So one thing, synopsis should be a gist of the case. You can have it 10 lines, you can have it 30 lines, but not, I would say never beyond the 1.5 page, unless there is some reason, a special reason for synopsis. This is one. Then there is a list of dates. List of dates, I have been taught that the list of dates should be minimal, but what is required, you cannot escape any date from that. Always from the list of dates, always remember, you write all the list of dates, all the events from the trial court. Suppose this is a family court petition. So when was it filed? What was the, if there is any interim orders are very important. Then thereafter, what is the final order? When was it appealed? What is the high court's outcome? Whether high court is allowed partly or what is the reason you are seeking, what relief you are seeking. So always remember that synopsis and the list of dates will give the complete case outlook to the judge or the examiner, who is examiner if he's seeking your answer sheet, and if the judge, then he is seeing your SLP and what is the relief you are asking. This is one thing. After synopsis and list of dates are over, then there is one more thing I would like to tell. This is 136. Under 136, whenever you write the cause title, always remember, see, cause title always carries the marks from the purpose of the exam. And in the regular course of, I would say in the regular course, whenever you are filing case, the cause title should be whatever is given in the High Court. If there is a little derivation from here and there, who were the parties before the High Court? What was the position of the parties before the High Court? Same should reflect in your 136, Article 136, synopsis, this, I would say, SLP is a cause title. Always remember that. And the position of parties, you cannot change. Whatever was it, there may be a position of, there may be some disease, then you have to get the legal heirs in ancestral property and other matters. Thereafter, they come the main parts of the SLP. The first part, see, there are some paras which are mandatory. You cannot change. There are 8 paras in the every SLP. Everybody knows it. These 8 paras are very important, and the SLP cannot be 9 paras, 10 paras. Now, the second para is most important, is question of law. Now here, how many question of law? I will first count the numbers. In how many question of law you will make? I always say make 1, 2, max 3. I have said in my first this lecture also. Always make 1, 2, 3. For this, I will discuss one case in the later part. Either 1, 2, 3. Don't, not more than that. Always remember only 1, 2, 3. Not maximum, not many cases, because question of law cannot be so many. Always remember 1, 2, 3. And see, I will read out one of my this case law SLP. Whether there is a bona fide and sufficient reason for DNA test when the daughter's blood group doesn't match the either of the parents. See, there is no facts mentioned in that. Whether there is a bona fide and sufficient reason for DNA test. So you have to go in Andy Tiwari's case in DNA. Then there is when the ratio laid down in Sukhendu Das versus Rita Mukherjee applies to this case. See, I have taken out one case of the Supreme Court. So it will be easier always for the judges to compare your case to the past cases. So question of law should be limited. 1, 2, 1 would be sufficient, I would always say. From the exam point of view, the reason is because always it is very, you have lack of time. In 3 years, you have to draft, I think, sometimes 2 SLP, 1 counter, 1 writ petition, 1 civil appeal, maybe 1 criminal appeal also. So there are many IAs also to be prepared. So in 3 years, it is very difficult, even though they give half an hour extra to you. This is all. Then there are declaration 3 and 4. Then there are grounds. Now, what is to be written in the grounds? See, grounds are always on the facts. Now, what are how many numbers for the grounds? Grounds, it may be 1, 2, 5, 6. If you write 10 grounds, I'm telling you, you won't be able to complete the paper. Always try to write at 1, 2, 6, 7 grounds, not more than it. I have seen people writing 20 grounds. Your SLP it will be weighty and it will be very difficult because the judges know if you write more grounds, then they don't know which ground to take up and they may not read it also. See, lengthy things are always avoided. In exams also, if you write lengthy, one thing, one loss, you lose the time, another loss, the judge may not read it and you may lose the time also and you may lose the important next question which you want to attempt. So ground should be 1, 2, 3, 4, 5, 6, maximum 6, 7, not more than that. Even in transfer petition, we are mentioning sometimes all the facts not required. Transfer petition is only up to the mark where why transfer is required. What is the reason? It may be maximum 3 or 4. Why transfer is required? She is having children with her or she is unable to travel. She has no money for traveling. These 2, 3 reasons are more than enough. Now, there is comes a ground for interim relief. Sometime I have seen ground for interim relief, we simply write because the balance of convenience is in our favor. That is the reason this SLP may be allowed and interim relief may be granted, stay may be granted. See, for seeking the interim relief, always remember you have to make out your case. In the interim relief, always ask Some good reason for interim relief. Suppose it is a divorce petition. Come with something, one error which Honorable High Court has committed below, and you are seeking the relief from the Supreme Court. So you should take out that error. Why why the balance of conditions is in your favor. If it is a bail matter, criminal matter, then it should be that what is the reason you are seeking bail. You have roots in the family, there is no antecedent, but give some good reason, whatever the reason, but give good reason for interim relief. Normally, see, there are marks for interim relief. Now then there also comes the interim prayer and the main prayer. See, the prayers carries the marks. In the Supreme Court, your examination, always the prayers carry the marks. There is a specific performer for writing the prayers, which we will discuss in the coming parts of the lectures. So the prayer should be very clear from which order you want to set it aside, why you want your SLP to be allowed, and what is the interim relief you are seeking again, why you want to state the operation of the Honorable High Court order. So prayer should be very specific and perfect. You cannot have prayer in your own words. No. Then again, I will say the language should be very decorative. We can always say, instead of writing simple prayer, graciously I am praying for. These are the things you can always add to this. Now we'll come to I have taken out the question paper of 2018. We have discussed the SLP. We'll come to there is one question in the 2018 question paper, that is of drafting of the counter. See, counter is one part. Whenever there is a notice issued to you, you have to file the counter. See, counter also carries sometimes 10 to 15 marks, and it is the one of the easiest thing to draft, because there is no big format for the counter. Always remember, for counter there is no specific format, and it is the easiest thing. You can always cover your mark, and counter can be short as 2 to 3 pages, and you have to simply write the paragraphs, and you have to just make small cause title, not a long cause title. So counter is the easiest thing. You can always cover the marks. Now, can you simply write the counter, how we file the written statement in the courts below, in the civil courts? No, please. Whenever you are writing a counter, always remember, look into the questions given, and you always try to give some judgments or some good reasons, because in counter it is very difficult to give reasons. Why? Because already the notice has been issued by the Honorable Supreme Court. So that is the reason you are filing the counter, or you have been ordered to file the reply. So whenever you file the counter, always try to give. Now I've taken up the question paper of 2018, which is about a family matter. It was about the custody of case of the children. In this case, there was children were in USA. The wife has brought them back, and High Court also has offered them again that children should go back to the USA court, because there was a USA court's order. Matter went to Supreme Court in SLP. Now, see, why the children custody should be given to the wife. That is one thing you should always remember. There's the welfare of the child. Now, welfare of the child, paramount welfare of the child should be considered. If you write simply, I do not think the examiner will give marks. If you write something extra out of it. Now, I've taken out few. Now, this is the one case laws we are taking, that there is a custody matter of the children. Now, for custody matter children, we have to go back to there is a leading cases also paper, where we are going to discuss one of the leading cases, that Geeta Hariharan's case, RBI. Geeta Hariharan versus RBI. Kindly note it down. Now, in this case, there was a discussion on who is the natural guardian of as per Hindu law, who is the natural guardian of the child. This case says that natural guardian will always be father, and in the absence of father, mother will be natural guardian. So you have to mention this case. There is also one more important case, Sumedha Nagpal, Gaurav Nagpal versus Sumedha Nagpal. This is one case which also speaks about the custody matters. There is also Sarita Sharma versus Sushil Sharma of 2000, year 2000. Sarita Sharma, kindly note it down, versus Sushil Sharma 2000. This is the case which I have also applied in my one of the family matters. The children from Pakistan, they were born and brought up there. Mother has brought them. Mother was Indian and the father was the Pakistani. But depending on this judgment, the children's custody were given to the Indian mother here. So there is always a way out. So you should quote all this, I will say citation. Unless he may not give the year, which year it is, but at least quote the citation. Sumedha Nagpal, Gita Harrier, and Sarita Sharma, Sushil Sharma. There is also a case of Kundu, which is also very Neil Kundu, I believe, which is also very one of the important cases. But these are few important cases. Now, what happens in drafting cases? What will be the question? Because drafting is a very big arena where anything can be picked up. Normally, whenever we go for the exams, the examiners say that we will be giving from the current scenario. Now, currently there is a one hot judgment, that is the ancestor property. Vinita Sharma versus Rakesh Sharma. If there is a question comes on ancestral property, and if you fail to mention this judgment, and if you do not know this judgment, then there will be some concern on the marking system. So if you want to get good marks, you should always quote this judgment. Vinita Sharma versus Rakesh Sharma, what was the ratio laid down in that? What were the previous judgments before that? This all you should remember. These are the two questions. I have discussed the SLP. I have discussed the counter, that is the reply to the SLP. Now we will come to the one very important thing. The portion of the drafting, or I would say AOR examination, is very wide. Everything under the sky is you have to study, like IAS exams. Everything under the sky is your syllabus. One very important thing which we have to always remember, most of the questions in 3 papers are covered from on the caste basis system. That is Indra Sawhney's case. Now Indra Sawhney and then TM Pai, all these cases are very exhaustive, and it takes our breath out of us, because it is very difficult to digest all that, and especially when you are appearing for exam, time is short. So how you may make notes, but then still at the last moment you do not know what to do. I have prepared little bit notes on that. See, from where this reservation of the education system or quota or in the jobs, from where it started. We have to go to Article 340. Kindly note down. Article 340 of the Constitution. What is Article 340 of the Constitution? See, if you mention Article 340, the examiner will be really happy. He will know that you have studied. See, Article 340 is about appointment of a commission to investigate the condition of a backward classes, people who are unable to get the job, education. So there was a Mandal commission appointed by the Morarji Desai ji. He was then Prime Minister. So you have to start from Article 340. Once the Article 340 is clear to you, then you may go a little ahead with Indra Sawhney's case. Now, see, again come to the, before you go to Indra Sawhney, come again to the Article 16. Article 16 should be very thorough with you. You should by heart with, especially Article 16, 1, 2, 3, 4. All these articles under the Article 16. Now, Article 16, 1 and 4 are very important. These are reservation kept made. Both the articles ought not to surpass 50%. What is Indra Sawhney case? There is a cap of 50%. Kindly make a note of it. In the Indra Sawhney's case, there is a cap of 50%. आप कितना reservation दे सकते हैं? Only up to 50%. So there is a cap of 50%. But in exceptional cases, the reservation may go beyond 50%. But it should be from the state government can do it. And again, there is a central government who can also do it in exceptional cases. There are, again, I have seen 10% fixation of the quota for the higher caste, but those who are from the economically backward classes. So this will always evolve. The law on this Indra Sawhney case will always evolve. So you have to always keep yourself up to date. So Article 16 is very important from the exam point of view. And if you read it from D.D. Basu, trust me, from D.D. Basu, you will find out that you will get many judgments which you can make note of it. Now, about Article 16, I would always say that there is always a development. Recently in Maharashtra, there is a lot of agitation on the Maratha quota. So that matter is referred to a larger bench because it is going beyond 50%. So it is before the larger bench. So even if one line mentioned by yourself, in the answer sheet that this matter is referred to a larger bench on the Maratha quota. That is about the SEBC Act. SEBC, just make a note of it. Socially and economically backward classes. Once this is over, then again you have to come back to the Indra Sawhney. You cannot go away from Indra Sawhney. This is one of the important judgment. Indra Sawhney has capped it up to 50%, but there is always a development and evolvement of the law. Then there is one more important case in this line after Indra Sawhney. This is Ramesh, son of Chotalal Dalal. I'm sorry. It is not that. It is Rajeev Kumar Gupta versus Union of India. Rajeev Kumar versus Gupta versus Union of India and others of 2016. This is one very important case after the Indra Sawhney. There was a office memorandum, OM in short, of 2005. There was no promotion to the economically disabled people also, those who came for promotion. So there was some dispute over it, and central government also taken out the by 2005 office memorandum that there will be no reservation for disabled people. But then there was a judgment of Siddaraju versus state of Karnataka. Siddaraju, SIDDARAJU versus state of Karnataka. This is a recent judgment 2020. Justin Rohinton Nariman's judgment it is. Now, Rajeev Kumar Gupta always said that there will be a 3% quota for the disabled people. This was again, it was the Prasar Bharati's case, and this was again made by way of SLP. It was challenged before the in the case of Siddaraju state of Karnataka, and Justice Nariman. He had held that Rajeev Kumar Gupta's case, it was upheld again, that there will economically or disabled people will also get, while in appointment also they will get the quota system, they will be allowed also in while the promotion. That is only 3%. This you should know. Then again, after this Indra Sawhney, there is one case I would like to tell you. While we were discussing the SLP, there is a question of law and there is a grounds. Now, this is one case I would like all of you to note down. That is Sarla Mudgal's case versus Union of India. In Sarla Mudgal's case, the husband was a Hindu. He was married. He converted himself to Islam and got married again. This case came before Supreme Court, All India Reporter, 1995 Supreme Court. And now this is a landmark case on the point of whether a husband who remarries after converting to Islam, will he be allowed, his second marriage will be legal? No, it will not be legal. See, any case when it comes to matrimonial and there is a thing that a husband converted to Islam, then what happens? Then you should know this is one of the landmark case. If matrimonial case comes, you see, you never know what will be asked in the syllabus. So you should know this case. And the beauty of this case, there was 2 issues framed in this case. And these issues are very beautiful. I will say you will get an idea कि question of law कैसे बनाते हैं. There was 2 issues which were discussed. Whether a Hindu husband who is married under the Hindu law can convert to Islam and marry a second wife. Another issue this was whether the Hindu husband after such act can be charged under section 494 of IPC. Because he was converted to Islam, he cannot be charged for second marriage. But no, the court set aside his marriage and these were 2 issues formed. ये जो दोनों issue है, ये दोनों आपके I would say question of law है. आप इस बात को ध्यान रखिएगा. If you read this, see, your drafting is always surrounded by the judgments. You cannot draft unless you know the judgments. So drafting is always surrounded by judgment. If you know the judgments, it will be very easy for you to draft. This is one case I would say which will give you what to draft and what not to draft and how many issues. Only 2 issues were framed. And this is तो आपका जो क्वेश्चन ऑफ लॉ, इट विल ऑलवेज स्टार्ट 1 or 2. I said in the beginning, it should be 1 and 2. If you write long, it will be very difficult to complete the papers, and the examiner may not be interested in reading the lengthy papers also. This is one case. Then there is one more case. See, SLP, sometimes there are two SLPs asked to draft. So one more case I would like all of you to, Ramesh, son of Chotalal Dalal versus Union of India, 1988. Now this case is related to a serial called Tamas. Tamas was somewhere in the, I think, 1988-87. It was telecasted, and it was about the Sikh and some riots about it. And it was there was already a book on this Tamas, and the serial was about to be broadcasted. But the board has cleared it. But there was some case in the Supreme Court, and this the Supreme Court allowed. And this case is related to Cinematography Act, read with right to speech and expression, Article 19(1). See, you can always cover the Article 19(1). See, if an SLP is given, and if you don't know Article 91, if you don't mention the Article 19, that right to speech and expression, then it will be, examiner will know that you do not know the Constitution. So it is very important that you know the Constitution and you can mention Article 19. So this is one case where you will get an idea how to draft an SLP. This is one very important case. Then Siddaraju versus State of Karnataka, I have already spoken. This you can cover. Apart from that, there will be a counters, there will be affidavit and certificate. There are sometimes the question is asked to us whether we should draft the certificate and affidavit. See, you have to read the instruction. If affidavit is not given, there is no need to draft it. There is no requirement of the certificates to be given. This is also one more thing here. Now also there is a writ petition or PIL. Sometimes writ and PIL, one option is given. I would always suggest go for the PIL, because writ petition sometimes it is a specific case, but for PIL you can generalize and you can give more cases in that. So whenever you draft the public interest litigation, it is very easy for you, because public interest litigation you can cover so many things, and the area you can cover in the public interest litigation, you can give more grounds, you can give your own words. So always try to opt for public interest litigation, which is the easiest method when you write for this. This is what I've covered. Now about the cause title, that is one more important thing. Sometime what to write in cause title, what names to be taken. I was always say take ABC, PQR or XYZ, EFG, small names. If you take big names or some artificial name also, it will be very difficult. Always write ABC versus CDF, something like that. So it will be easier for you to draft. If you give long names or some hypothetical names, it will be very difficult, and you cannot write your names in the SLP. Always remember, never ever write your names in or give any hypothetical names. It will be counted against you. Always remember that. Now for drafting paper, there are so many things which we can cover. Still, I will tell you, for drafting, one thing, you make your own notes. If you read DD Basu's, again back to the DD Basu square one. If you read DD Basu, it will prepare your three question papers of your examination. DD Basu is very important because it will give you how to prepare the question of law. Grounds may not be there, but question of law, of course, you will have. Then there is a possibility that you may get out of that, you may get some notes on the I mentioned Indra Sawhney's case, TM Pai's case. These all cases you will find. If there is an updated version with you of DD Basu, you will get all the case law. So you can make small notes. And if you mention case laws in your examination or your answer sheet, it will be very easy for you. So always remember, take the DD Basu, try to read it from there and make a note of it. And if the reason people get less marks in drafting, because they could not attempt the complete paper. And the reason for that, because you are unable to write fast. So always remember, whenever you are appearing for the drafting paper, I will always ask you to write fast and start writing SLPs, drafting, and get it corrected from some seniors. It will be easy for you. Those who have cleared the AOR exam, talk to them, give your SLPs to them. It will be very easy. SLP read petitions. And I would again say the skill lies in reading the judgments. The more you read, the more you will be able to draft properly, which goes again for me also. Even though I am an AOR, Vandana is in AOR, I will always tell you, the more we read judgments, our drafting will be more perfect. So the thing is, if we do it properly, it will help us. The thing drafting is always is, I will say, आपका जो निचोड़ होता है वो आपके रीडिंग का जजमेंट्स का होता है. अगर आपको ड्राफ्टिंग अच्छी करनी है और आपको 100 मार्क्स, एंड ड्राफ्टिंग इज अगेन अ सब्जेक्टिव मैटर. द रीजन इट इज अ सब्जेक्टिव मैटर because examiner who is reading, he may not like, or he may not like, his view is different. But what I have seen on more of this side, they see the reasoning, what you are able to take out from the high court. See, high court has the language should be, high court has made error. High court is the decision taken by government is arbitrary, it is not fair. तो पूरा लैंग्वेज जो है वो कॉन्स्टिट्यूशन का आएगा. ऑलवेज रिमेंबर, आपका कॉन्स्टिट्यूशन बहुत ही पक्का होना चाहिए. एंड डीडी बसु, द लैंग्वेज इज वेरी डेकोरेटिव, वेरी ऑर्नामेंटल. ड्राफ्टिंग में से कि लैंग्वेज नहीं देखा जाता है, बट लैंग्वेज देखा जाता है. Another important thing, with all the humbleness, I will say, never ever make spelling mistakes or English mistakes in the drafting paper, because that is one paper where your language is always seen. तो आपका लैंग्वेज आपको ध्यान रखना है. यू कैन नेवर मिस.
पुष्पा बनारस में रहती है,
तो स्पेलिंग मिस्टेक्स नहीं होना चाहिए, ये सब का आपका ध्यान रखिए. तो ड्राफ्टिंग इज वन ऑफ द ब्यूटीफुल पेपर. इट